Good morning, everybody. Welcome to the Courtroom Files Live. Happy Thursday. We will start off today with Judge Simpson.
I believe that conflict exists. Honorable court hearing these matters. If conflict were to arise, our office would waive such conflict so that this honorable court could hear these matters.
Thank you. And the court, for its part, also does not believe there's conflict either in the court rules or the cases decided thereunder. To the extent a conflict does exist, the waivers court will consent to hear the matters. Court does call the case of the People's State of Michigan versus Willie Eugene Collins.
We're ready in that matter.
Good morning, Your Honor. Shalom to the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Willie Collins. Mr. Collins, please state your name for the record.
Willie Eugene Collins.
All right. Your Honor, today is the date and time set for the probable cause conference. I've discussed with my client and misdemeanor offer, which has been offered in this case. I have, with his consent, assigned an advice of rights plea form, and we also have the plea form now.
Okay, I need that. Right. Plea form indicates that the defendant would be pleading guilty to the charge of use of methamphetamine, the one-year offense. Upon his successful plea, the felony charge, count one, would be dismissed. Looking at the form, that's the court's full understanding of the agreement.
That's correct.
As I understand, Your Honor, my client is ready to be sworn.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record.
Willie Eugene Collins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You had an advice of rights form explained to you
Yes, sir.
and gave permission for your counsel to sign it?
Yes, sir.
All right. Do you have any questions regarding any of those rights?
No, sir.
You understand that by entering this plea that you're giving up your rights as contained in paragraph 5, your trial rights?
Yes, sir.
All right. You understand also you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty?
Yes, sir.
July 26, 2023, at the location of 501 East Michigan Avenue in the city of Ypsilanti, Washtenaw County, state of Michigan. Did you have methamphetamine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was methamphetamine?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
People are satisfied.
The defense is satisfied, Your Honor. Thank
Court
you.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this case will be
10 a.m. before Judge Barr.
May 14, 2025. I'm sorry,
10 a.m.
10 a.m. before Judge Barr.
Thank you very much.
Bond will continue. Thank you. Thank you, Mr. Collins.
I'll be in touch, Mr. Collins. Okay.
Court calls the case of the people versus Chalice McGloin.
Andrew Tillman's appearing on behalf.
And Assistant Public Defender Tanazi Carey, Your Honor, on behalf of Mr. Chalice McGloin.
Sir, can you please state your name?
Chalice McGloin.
Thank you.
Judge, we respectfully request that this matter be set for preliminary examination, please.
All discovery is complete.
To our knowledge, Judge.
What the? It makes sense. What? I don't know that they have to do a writ. You're not gonna have to do a writ on this. Gail will come get him or go get him, right?
So he's being housed there.
I think he's being housed in Saginaw, but not by Saginaw. We're housing.
I would, we could maybe just have an extra week, just in case.
We don't have a problem with that, Your Honor.
On the 13th, all right. Discovery is complete. I will set preliminary examination will then be set May 13th, 2025, 9 a.m. before me. That'll be in person. Bond will continue.
Thank you, Your Honor.
Thank you. It's 13th. No, it's the 6th. That's it. Right. All right. Thank you. Thank you, sir. Court calls case People versus Seth Priester.
If you're to me, doesn't.
This is
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
Priester, can you state your name, please?
Seth Priester.
Thank you. All right, what are we doing in this case?
Your Honor, I'll set it for an exam.
All discovery is complete.
Yes. I believe so. I have both electronic and paper.
There are 911, you have that?
I don't know. No. Just accepted the case 2 days ago. They just sent me the discovery yesterday evening. But I believe we have enough because I have.
Is all the discovery complete?
As far as the people know, Your Honor, there's a co-defendant in this case, just so the court is clear.
Co-defendant.
Also on today's docket, I have that as the Bossier Hennings.
Who's representing? You're representing him?
Yes, there's a conflict in the case, so.
So you're not representing him?
We're still the attorney record.
Ms. Constantino did ask me about it earlier. She's in the court.
Where is she?
She's on today's docket. She might be meeting with the client or in the hallway.
Might be next door.
Where is she? She's so small. We don't see her. So is she in the room or no?
No.
Okay. In speaking with her, were you under the impression she was also going to be asking for an exam?
She was not. She just got appointed, I think, like this morning, and she hasn't even gotten discovery or anything yet.
All right. Ms. Barnwell, you want an exam?
Yes, Judge.
People have their witnesses available to 6?
We'll certainly try our best, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. before Judge Barry.
One split second, Judge. I'm not available on that day, Judge. I'm available on the.
Why don't we do this? Let me pass this matter briefly. Why don't you go talk to Ms. Constantino, since these are co-defendants? I would rather, if we can, through some judicial efficiency, get a date that this could be heard where both defendants can be heard.
Okay, Judge.
All right. Mr. Priester, hang in there. I'm going to pass your case for a moment. All right?
Yes, sir.
Thank you.
All right. Excuse me. Good morning again, everyone. Welcome to the Courtroom Files Live. Let's go a few minutes east of Judge Simpson and say good morning to Judge Meineke.
A little bit.
Sorry. Yes, I would like to do that.
Okay. What I'm going to do, Ms. Newton, is I'm actually going to stop your video, and that should make it so that our audio connection is better. So don't worry if it says host to shut down your video. You haven't done anything wrong. It's just to make sure that I can hear you better, okay?
Sounds good.
All right, Miss Newton, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please put your hand down. Miss Newton, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes,
Have you had a full chance to discuss this with your attorney?
I have.
And are you satisfied with your attorney's advice?
Yes.
You're pleading guilty to public intoxication. That's a misdemeanor charge, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, want to be appointed for you at public expense. Hold on one second. Okay, Ms. Newton, you have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of these charges, and your guilt has to be proven beyond a reasonable doubt. Ma'am, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes, I do.
You plead guilty, there'll be no trial. You understand that?
I do.
Has anybody promised you or threatened you in any way?
No.
It's your own choice to do this?
Yes.
All right, directing your attention to February 16th of this year, 2025. Were you in the city of Royal Oak in the area of O'Toole's?
Yes.
All right. And did you engage in behavior that was disorderly in nature, created a public disturbance, and was it related to a high level of intoxication?
That's correct.
Okay. Satisfied, counsel?
Satisfied, Your Honor.
I too am satisfied the plea is knowing, voluntary, and accurate. I'll accept the same. I need to find out a little bit more about Miss Newton and the incident here. Obviously, she's had some connection with the criminal justice system before. We want to make sure that this episode is the last one. So, Miss Newton, here's what's going to happen from here. You and your attorney are going to get 2 more dates. One is going to be an interview with my probation department. That'll be on Zoom, like you and I are talking right now. Then we'll get an in-person sentencing date where you and your attorney will actually come into the courtroom and we'll do the sentencing. Now, before that date, Mr. Barrow will get a copy of a pre-sentence report. That's basically a report that's prepared by my probation department after they talk to you. And it carries with it some recommendations. Some I may follow, some I may not. You and your attorney may have some arguments about them, but you'll be able to prepare for that in advance. In the meantime, your job, Ms. Newton, is continue to stay on top of your testing. I want to make sure that you're staying away from drugs and alcohol and trying to move forward with your life in the healthiest way possible. Deal?
That sounds good.
All right. So we'll see you back here for sentencing. Mr. Barrow, good luck. Ms. Newton, good luck. Take care.
Thank you, Your Honor. To you and your staff, as always, have a great day.
Okay, Judge Fleischer is off to a timely start this morning, so we'll go say good morning to him while he works through his arraignments. FYI, we voted as a community yesterday after the testimony in the trial to pick up closing arguments in the verdict today. We will do that about halfway through the show, so in about an hour.
What, 17?
Yes, sir.
I'm sending you now for a drug and alcohol test. I want to know what, if anything, is in your system. You're to go test and then you're to come right back. Do you understand? If I find that you have a weapon, I will revoke your bond, put you in jail. No more PR bonds. And let me tell you, those jails that you're in juvenile are a lot different than our jails. So get a clue. Do you understand?
Yes, sir.
Okay, take a seat for me momentarily, please. Cesar Orta, come up. Do you speak English, sir? No. Okay, toma asiento. Do you mind calling translator, please? McLaurin, come up, sir, or ma'am. Good morning. Sir. You're charged with failure to stop information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. This one is rather long-winded.
It's okay. Got time.
On April 16th, 2025, in Harris County, Texas, officers were dispatched to a crash major on MLK Boulevard. The complaining witness stated that he was approaching an intersection with Crest Ridge. The complaining witness stated that he saw a black Malibu on Crest Ridge. He also stated that he had a green light and proceeded through the intersection. The complaining witness also stated that the driver of the Malibu ran the red light and hit the passenger side of his truck. The driver of the Malibu pulled over into a parking lot of a gas station. He stated that he thought he had saw the witness. The complaining witness stated that he thought that he saw the witness rather than the defendant get out of the driver's side of the Malibu. The complaining witness did observe that the defendant had also been in the Malibu. The complaining witness stated that the witness approached him and was taking pictures of the complaining witness's truck. The complaining witness stated that the witness was saying something in English, but the complaining witness could not understand what the witness was saying. The witness then walked off and got back into the Malibu with the defendant. The witness and the defendant left the scene without giving the complaining witness any of their information. The complaining witness was able to get a picture of the Malibu's license plate and called the police. The defendant's motor vehicle was located and a traffic stop was conducted. The complaining witness went to the scene and identified the witness and stated that he believed it was the witness who was driving the vehicle rather than the defendant. The witness and the defendant both stated that it was the defendant who was driving the motor vehicle at the time of the accident. The witness and the defendant stated that the defendant was driving the motor vehicle and that the complaining witness's truck hit their motor vehicle. The witness and the defendant stated that the defendant pulled into the gas station parking lot and that the witness got out of the front passenger side of the motor vehicle and walked around to the front of the car to look at the damage. The witness then walked toward the complaining witness and took pictures of his truck. The witness tried to talk to the complaining witness, but the complaining witness only spoke Spanish, as relayed by the witness. The witness thought he heard the complaining witness say, I go, in which the witness thought that he meant that he was going to leave the scene. The witness walked back towards the motor vehicle and got into the front passenger side of the Malibu, and the defendant got into the driver's seat. The defendant left the scene without giving the complaining witness any information. Neither the defendant nor the witness called the police to make a report about the accident. And the officers went by the gas station at 6908 Martin Luther King Boulevard and were able to recover security camera footage of the accident. The officer observed the video footage showing the complaining witness's motor vehicle traveling northbound down the outside lane of MLK Boulevard and approached the intersection with Crest Ridge. The defendant's motor vehicle can be seen headed westbound on the 6800 block of Crest Ridge and appears to slow down at the intersection with MLK Boulevard. The officer was unable to see what color the light was due to the distance. The complaining witness's truck can be seen entering the intersection, and the defendant's motor vehicle can be seen going forward and striking the passenger side of the complaining witness's motor vehicle. The driver of the Malibu, the defendant, drove the car to the gas station parking lot, and the witness can be seen getting out of the front passenger side seat of the motor vehicle.
I think good.
Yes, sir.
Okay. Mr. McLaurin, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please? If you do not have a license, a Texas driver license and liability insurance in your name, car insurance, then you're not allowed to drive, and that is a condition of your bond. Do you understand?
Yes, sir.
If I find that you drive without either, I will revoke your bond, put you in jail. No more PR bonds.
Yes, sir.
Do you have the ability to hire a lawyer?
sorry, Your Honor. It's out of Nevada, so we're just trying to figure out the eligibility.
It's all right.
Appears to be valid out of Nevada, Your Honor.
Okay. For now, Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you fill it out and I'll take a look. I need to know everything about you. I'll have you sign a reset and then we'll have you take us to the seat in the jury box to give you time to fill it out. Yes, sir. Please.
Now that more of you have filed in another formal good morning to everybody, welcome to the Courtroom Files Live. Happy Friday Eve. Just to excuse me, make sure we're all clear on stuff. Yesterday we did the Judge Fleischer trial, almost a 5-hour stream. They kind of went on forever. We did cover the testimony. We did not stick around for closing arguments or the verdict, but I have those, and around the top of the next hour, we will get in the Wayback Machine and we will take a look at the closing arguments and the verdict. So hang tight for that.
I'll see you here. Mr. Orta, come up. Orta.
Buenos días, Tomás, escuchemos.
You are Caesar Orta.
Yes.
Mr. Orta. You are charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford
Just
one.
one moment. Can I get a tissue? It's chewing gum at disturbing. I'm sorry.
I was going to ask him to spit his
Yeah.
gum.
What is it? Chica. Okay. Go ahead, yeah.
You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 16th, 2025, in Harris County, Texas, officers were dispatched in reference to a failure to stop and give information. The officer met with the complaining witness, who stated she was traveling on a private drive at La Michoacana when a motor vehicle driven by the defendant reversed into her motor vehicle. The complaining witness stated the defendant got out of their vehicle with a nervous and concerned look. The complaining witness asked for insurance information or money to repair her damage. The complaining witness states the defendant got very argumentative and stated that there was no damage. The complaining witness stated that the defendant said, "I have to use the restroom," and began walking away without providing any information. The complaining witness was able to capture a photo of the defendant's face. The complaining witness estimated her cost of repair to be $4,000. Officers made contact with the defendant at a nearby Shell gas station. It is noted that the defendant was in the gas station for 1.5 hours. When the defendant was asked why he didn't use the restroom at the meat market where the incident occurred, he responded that he didn't want to.
Have you run his license?
I can do this, Your Honor.
Mr. Orta, I'm going to find that there's probable cause to go forward with your case. If you do not have a Texas driver license and liability insurance, then you are not allowed to drive. If I find that you do, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it on a daily basis, they will put an immigration detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
Your Honor, we don't see a DL number on file. I'm checking the office board to see if they got it, but I'm not seeing one for us.
No.
He doesn't have a driver's license.
This is an affidavit that you're going to be signing with me today. This is a promise that you're making to me that you're not going to drive. I don't care what is going on in your life. If there's a burning building and you have to save 5 kids, I don't care. If I find that you're driving, it's not going to go well for you. Do you understand?
Stop.
Exactly.
Do you have the ability to hire lawyers, sir?
¿Puede ocupar su propio abogado? Es la pregunta.
Oh, okay.
¿Puede, sí o no?
Sí, puedo agarrar un abogado.
I can hire an attorney.
Okay, we are going to give you time.
Le
So
vamos a
I will
dar-
have you come over here, swear to us that you're not going to drive. I will get you to the Jamaica where you will sign a reset, and then we'll have you take a seat while we get your bond conditions. Once you sign bond conditions, at that point, you'll be able to leave. When you come back, please have a lawyer, sir.
Y al regresar, trae un
And then-
abogado, señor.
Okay.
Excuse me, do you mind filing those conditions, please? No driving without either.
Aaron, do you want your TV on? I think we had it published off the trial.
Don't matter.
Esto es un documento que usted va a publicar.
Estefania Morales, do you speak English, ma'am?
Yes.
Come on up.
Sí.
Good morning, ma'am.
Good morning, Your Honor.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On July 27th, 2024, at about 9:20 PM, officers arrived on scene and observed 2 vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car. The witness stated she saw defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having 1 beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turns, a 3 out of 4 on the one-legged stand. The DIC was read and the defendant considered to a breath test. The first result was 0.175 and the second result was 0.181.
All you said is there's an accident and she had missed 1 beer. Was there any slurred speech, bloodshot eyes, odor of alcohol?
Sure. In summer, but it looks like we just have the car crash and the admission of the 1 beer.
Good morning. Can you hear me?
Judge, can you hear me?
Yeah. Can you hear me?
Yeah, I'm here. Yes, sir. I'm sorry. I'm down in Galveston. Yes, sir. I'm here on Mrs. Morales.
Yeah. She's actually right in front of me right now, Michael.
I see it. Perfect. That's why I jumped on.
Have you heard PC yet?
No, sir.
All right. Do you mind reading it one more time?
Absolutely, Your Honor. On July 27th, 2024, at about 9:20 PM, officers arrived on scene and observed 2 vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car.
The short answer,
The witness stated she saw defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having 1 beer. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, a 7 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and a breath test was given with a first result of 0.175 and a second result of 0.181.
I didn't hear anything about any kind of slurred speech, odor of alcohol, bloodshot eyes. I didn't hear any of that, Michael, so I'm just finding no probable cause.
Okay.
You know, Ms. Morales, we have enough destruction on our streets, enough death from DWIs every single day. You know, just don't kill someone, please. If you're gonna drink, if you want to have 15 beers, 32 shots of tequila, 1 button on your phone, $40 with an Uber will get you anywhere you want to go. Use it.
Seth?
Please.
2 things. First off, she's lucky. That was a high blow that they ended up with. It wouldn't surprise me if this one gets indicted in a grand jury, but we'll see. Second off, I've said this before, 32 shots of tequila, you're not calling an Uber, you're calling a hearse. Just saying. Let's see if he's got any more arraignments.
Margarita Sanders. Good morning, ma'am.
Your Honor.
Ma'am, you're charged with theft by check. You're facing up to 6 months in jail and a $1,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Thank you, Your Honor. On June 30th, 2019, the defendant issued a check for $114 as payment for 4 containers of fruit, 3 containers of wine, 1 container of orange juice, 1 container of chips, 1 container of pizza, 3 containers of water, 2 containers of bread, and 1 container of beer. The bank returned the check marked NSF. The defendant was identified through the Texas identification number, which was written on the front of the check.
So what was the total?
The total was for $114.97.
Okay. So Ms. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case. Ma'am, do you have the ability to hire a lawyer? Okay, I can have you fill out an application today. We'll take a look to see whether you qualify. I'm ordering you as a condition of your bond not to write any checks like these anymore. Do you understand?
Absolutely.
Okay, don't pick up any new cases. It's not going to go well for you, okay?
Yes, sir. Yes,
All right,
sir.
so Deputy Miranda's going to give you an application. I'm going to have you go to Jimay, sign a reset, and then we'll have you take your seat in the jury box, man. And then I'll appoint your lawyer.
What's her patient right to? Yeah, yesterday.
I have one more. Victoria Williams, come up. Good morning, ma'am.
Morning.
Ms. Williams, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Thank you, Your Honor. On April 16, 2025, in Harris County, Texas, an officer was dispatched to an assault call. The officer met with the complaining witness, who stated that he and the defendant are currently married. The complaining witness stated that he asked the defendant to be more respectful of him. The defendant became angry and started slapping complaining witness in the right shoulder several times, causing pain. The complaining witness pulled the vehicle over and the defendant punched him in the face, causing pain. The defendant then began to kick him in the head, causing pain and bleeding. The defendant admitted to kicking the complaining witness in self-defense.
And I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand? There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? Do you have the ability to hire a lawyer, ma'am? Okay, I can have you fill out an application. We'll take a look to see whether you qualify. For now, I'm gonna have you go to Jemay, sign a reset. We'll have you take a seat in the jury box. I'm going to generate bond conditions for you to sign. Do not leave until you sign them, otherwise a warrant will issue. Please. So can you file no contact, no weapons?
Yes, sir.
That's it? Oh, makes sense.
Okay, he's done with his arraignments. Again, about the top of the hour, so 35 or so minutes from now, we will go to the closing arguments and the verdict from yesterday's trial. Let's go say good morning to Judge McNally in Woodhaven, Michigan.
Your Honor, I was up here for 5 years and you came in here for court dates. What would you think of me? You'd have every right to think I have no business sitting here. I have no business holding a job at a fast food restaurant putting salt on fries. Give me a break. All right, you're telling me he doesn't remember. I'll take your no contest plea to disorderly. Ms. Foley-Carter, your name?
Caitlyn Foley-Carter on behalf of Brownstown Township, Your Honor.
You understand a plea to disorderly is punishable by up to 500 fines, 90 days jail costs, or all those, right, sir?
Yes, Your Honor.
You understand a no contest plea has the same effect as a guilty plea, correct?
Correct.
And you understand that you enjoy the presumption of innocence in this country, and they have to prove you guilty beyond a reasonable doubt. And you have the constitutional right to a trial by jury. And if you plead guilty here, you're giving up your constitutional right to a trial by jury. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving the right to remain silent throughout a trial and to not have that silence held against you and to cross-examine their witnesses and bring in your own. Do you understand that?
Yes, Your Honor.
You still wish to plead no contest?
Yes, no contest.
You stipulate I can use the report to establish a factual basis?
Yes.
I've added Mark Peoples 1 to the charge, disorderly person. How do you plead?
Guilty.
No contest. Well, you got
no contest.
All right, let me review the report. All right, based on my review, I find there's a factual basis for the plea. Are you on probation or parole right now, sir?
No, Your Honor.
Anybody force you to plead no contest?
No, Your Honor.
Are you aware that you have a warrant out of the 34th District Court?
I took care of that and they dismissed it.
When did you take care of that? That warrant, now this, that warrant was issued back in May 30 of 2018.
The 34th District Court, that is
Romulus.
Oh, that is for a civil matter, and I paid on all of those after that, like several. It was for like a civil case where it was for like a construction matter where I accidentally did some damage with some equipment.
Real quick, we're getting a little edgy in the comments, which I don't have a problem with. We talk things out. I'm cool with that. Let's all just remember my one standing rule, and that's that we all be respectful. So that's all I ask, just so we're all on the same page.
And the court administrator responded, probably at my direction. The court is in receipt of your letter to the court dated March 13/21, wherein you asked the court to close the case because you resolved the civil matter with Brownstown Township. Please be advised the court cannot close the case without a motion by the prosecuting attorney to dismiss it. As of today, the court has not received the motion to dismiss from the prosecuting attorney. Your case was scheduled for a final pretrial on January 27/21. Because you failed to appear, the court entered a bench warrant. Mr. Khan, you are 32 or 3?
I just turned 33.
It's time to grow up, okay?
He's done a lot of growing up, Judge. He started off, his past was a little.
I'm gonna sentence him now.
Okay, and Judge, the victim, I think I want APA Foley-Carter to let us know. I asked that the victim either waive their right to a victim.
They don't want to appear on this, do they?
They do not, Your Honor. It's my understanding that Mr. Khan no longer lives there and has no reason to return.
I'm not.
He's gone, Judge. He doesn't live there. We're asking fines, costs, closed file, no probation, no jail.
Mr. Khan, anything you'd like to say?
Just remember, Mr. Khan, it is a no contest plea, so please don't comment on anything regarding the underlying facts of the case. Thanks.
All I would like to say is, hey, I just want to get this matter taken care of, put it behind me, and, man up and own up to anything that I may have done that I shouldn't have done, or, acted in a way where maybe I could have responded and handled the situation a little bit better. I do totally respect you, Judge McNally.
It's not about me. I want you to understand, this is not about me. This has nothing to do with me. Honestly, it has nothing to do with me. It has everything to do with respect for this system, which is the greatest branch of government that's still in the greatest country in the world. And I take offense as a citizen, not as a judge, but as a citizen, when people think they can just ignore courts like this. It's like you are ignoring the greatest branch of government, bar none, in this country. That's what you're doing. I take offense to it. Not for me. It has nothing to do with me. I'm just a little pawn sitting here until the people tell me it's time to go. In this case, the Constitution's going to tell me it's time to go in 6 years. That's all I am. I'm not sending you to jail, Mr. Khan. I'm just agitated when people treat the system with such disrespect. That's how I feel about it. Some might agree, some might, it's too harsh, it's too, I could care less. My family's been in this profession for nearly 100 years. And this is just not the way I was raised. That's all I'm going to say. I'll let it go. I'm not going to send you to jail. I'm not going to put you on probation. I'm not going to give you a court work program. I'm not going to give you community service. I'm not doing any of that. So you don't have to grovel here. I'm not looking for that. I'm looking for people to be responsible. Anything else you'd like to say?
No, that's it, Your Honor. I thank you.
500 fines, a hard cost, 75 victims' rights, $50 justice assessment, 40 in attorney fees, 765 or 90 days. Can you pay that today or do you need time?
I need time.
How much do you have today?
So I posted a bond for 300. If we can apply that, and then whatever the balance is, I can have it paid off in 30 days.
Lisa, do you have a bond on this? I don't see a bond receipt in the file.
Let me check.
Maybe I set one and forgot to write it down on April 24th. It wouldn't surprise me.
He posted.
I'm sorry, on April the.
Yeah, he posted 300 on February 21st. You set the bond back in January.
Okay, so it's 3,010%, is it?
Correct.
And it's in his name?
Yes.
Yes, it is.
Okay, so of that will apply the bond, but by law, 10% we have to keep. So So you got 270 to apply. Now I'm gonna let you set your own payment plan, and you're gonna understand if you don't have the money, it's not a problem on any of these due dates, but you're gonna give me the courtesy of calling the court and saying, can I speak to the judge? In which case, I'm gonna give you an extension to pay, if we have to do it 112 times. Just don't ignore me again. Now, set your own payment plan. Tell me how much you can pay and when after the 270 today.
I can have it paid off by May 30th.
Are you sure?
In full, yes, sir.
All right, May 30th it is. If you don't have the money, what are you gonna do? You're gonna call the court, we're gonna go on Zoom, or you're gonna walk in here, Honor, before the due date, 8:30? There will be no questions asked. I'll give you an extension. I don't care how many times we have to do it. All right?
It was a pleasure representing you, Mr.
Good luck, Mr. Khan. Thank
Mr.
you.
Baldwin. Thank you, Mr. McNally.
Okay, we'll switch back to Judge Fleischer, but real quick to just address the series of comments that we just had. I'm not interested in overly policing the chat here. It's just not how I roll anyways, but I do have a couple of simple rules. One is that we are respectful to each other, because I'm trying to build a community here that's different from what everybody else has got going on, and disrespect isn't going to be part of that. I don't think we got to a point of being disrespectful, but we start going down certain lines, and it's only a step away, which is why I put out the warning to everybody. Also, we don't do politics here. We do law here. I'm not afraid of discussing politics. It just isn't the space for it. Everything devolves into politics, it would seem, and that's another thing that I'm trying to not do on this channel. Let's talk about law. Let's have fun. If you want to talk politics with me, find me in another space, and we'll do that. Not a problem. But we're kind of skirting that line a little bit here. I don't think anything got out of those couple of guidelines, but we were close, which is why I gave the advisory that, hey, let's not go there. But again, I want us to have fun, and I want us to have free speech and be able to talk. I think my couple of rules regarding this space, though, are in line. I hope you understand it, and I hope you respect it. We'll leave it at that. Let's go back to Judge Fleischer.
Sales receipts were provided that showed the debit card made a payment by the male individual. A total of 15 boxes of Pro V1 golf balls were stolen. The total loss for Academy Sports and Outdoors was $825.
Ms. Griffin, I'm going to find that there's sufficient probable cause to go forward with your case. I'm now barring you from going to any academy. You understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you as a condition of your bond not to have any contact with the co-defendant in this case, Mr. Zimmerman.
That's her fiance, Your Honor. No contact?
Nope. Now, we've given you a lawyer. It is your responsibility to stay in touch with him.
Yes,
If
sir.
he tells me that he can't get a hold of you because you're ducking and dodging phone calls, I will issue a warrant for your arrest. No more PR bonds if you become a danger to my city or you pick up a new case. Do you understand?
Yes, sir.
So for now, I'm going to have you sign a reset with Jamae. We'll have you take a seat in the juror box while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go.
Okay.
Because you have a lawyer, I will waive your appearance, meaning you don't have to waste your time coming to court, but you must stay in touch with them. Like I said, if you're gone in Alabama and you're just not remaining in contact with them, I'm going to issue a warrant. And I'm going to tell you, if we have to pick you up in another state, you'll spend quite a bit of time in custody.
Yes,
You
sir.
understand?
Yes, Your
I'm
Honor.
not saying this won't be a problem with her, Judge. Just kept in good contact since they initiated.
Okay, good. I hope so. Just don't be a danger. That's all I'm asking. You
Absolutely.
understand?
Yes, sir.
Okay. All right. Good luck. Thanks, Colin.
Okay, Linkman, here's my take on it. And I'll use this analogy. For me, politics is how the sausage is made. But what we're doing here at the Courtroom Files, when we're watching court, where we're monitoring court, we're talking about the actual sausage itself, how it tastes, its texture, stuff like that. Okay? If you want to get into how the sausage is made, well, there are certainly ways that you can do that in your local community through, supporting the party that you choose, through voting, through stuff like that. And there are spaces all over the interwebs. Half of friggin' YouTube is all about the politics and how the sausage is made. I'm more interested in its taste and its texture here. If that makes any sense, it's the best analogy I can give you. But that is because we can't affect on this level as a community that's coming together not only here in the United States, which is still 50 states, but we have viewers all over the world. We had a guy from Australia yesterday who tuned in for a while at like 1:30 in the morning to watch with us. So, you know, how the sausage is made, honestly, it starts at the local level. So do that there. Here, let's just talk about how we like it and what we might change and stuff like that. I hope this all makes sense. It's a fine line to walk. I know that. But I'm of the personal opinion that not everything has to devolve down to the base level of politics, because if that happens, what's the point of any of these different channels, honestly? If it all devolves down to that, then we don't need 1,000 spaces for that. We can do it with a couple. Trying to do something a little different here. Again, I hope all of that makes sense. I want to talk. I'm not trying to lecture. I hope you all get it. But I guess put sausage. I'm just gonna not come on. Link, I like you. I respect you. I honestly don't know what you want from me, though. I don't know what you're going for. I don't know what you're getting at. I don't know. Again, I like you. I like talking to you, but I don't know what you're looking for here. Let's get back to Judge. We've talked enough about this.
Today, if it were not for the fact that there are felonies entangled with each of these misdemeanors,
None of them have any kind of relation. Our cases are all prior to the felony cases. So I don't think that they have any relation. Show me that they are. So hold on. I don't want you to talk here in front.
It's okay.
Just something you need to talk about, but
Next time we'll be ready, trial or not.
so
Okay.
just, do you have offers on these cases, please? Anthony, I'd like Mr. Stewart tested within a week, please.
We have a couple who were eventually withdrawn. I'm scrolling through the cases here.
Okay, well, regardless, if you can, please put an offer at least 2 weeks prior to the next setting so that they can get ready. It is your responsibility between now and the next setting to get with the lawyer that we've given you to go through all the evidence to see what you want to do. I'm not waiting. There's way too much drama. Your cases are too old, and I'm not waiting for the felony cases to drop. Do you understand? I will give you 30 days. At that time, it's plea or trial. Okay, Colin, thanks.
Thanks, Judge.
So he needs to meet with the pretrial before he leaves.
Yes. Yeah, we'll do this condition just a minute.
You want him in the jury or back? You want him in jury box or back?
That's fine. Just don't leave until they've met.
Judge.
Curfew will remain for Mr. Stewart as well, right? It's 9 p.m. to 6 a.m.
Yeah.
GPS and that testing would be.
All right. Okay, hi.
Judge, may I approach?
Yes, ma'am.
Thank you so much. I am here for my colleague Adam on Eric Ramirez.
Hey.
Say hi, Father.
So, what's the word?
Judge, Mr. Ramirez is in the hallway. So I believe he was asked to sit outside. I spoke with the state. Per my colleague, there's some new information. I provided it with the state. They're wanting a short reset to, I think, try to reach the complainant again and potentially reevaluate the case.
So the case is 200 days old, so I'll give you a week. At the next setting is clear trial then. So 1 week, have them here. And then, is there an offer on the case now? Or you said there was, right?
I'm sorry.
There is an offer now.
I
You just
believe
want
there
to.
is an offer. Yes.
Okay, so it's a week and then clear trial.
Yes,
Okay,
perfect. Thank you, Judge. May we be excused?
Yes.
Thank you so
thanks.
much.
Perkins.
Good morning, Judge.
Hey.
Hey, I have Miss Collins on docket today. She's a county case. There has been no update from Galveston County. she's been reset there till May 2nd. To prevent from having to reset her every week, can we revoke her bond until we can actually physically get her back into court and then reinstate her once we can do that?
Sure.
Okay.
Okay, so I guess what we can do, she's there now, right?
Yeah, so she's still in custody. She doesn't go,
So what we'll do is let's do a bench warrant, because I think that that'll get her here quicker. But I'll set it at 5,001. I'll just raise it up by $1.
Okay. Okay.
And then we'll do a bench warrant today.
Okay, thank you, Judge.
Excuse me.
And then I guess once we get her, we'll reach out to you and let you know when she's here.
Okay, thank you so much, Judge.
Yes, ma'am.
Have a good one. May I be excused?
Okay, yes, ma'am.
Thank you.
Destiny Collins, top of page 7, 5,001. Well, yeah, I'm gonna revoke it and I'll try to do it both so that we try to get her here as quick as possible.
To get us a little bit of variety, since we're going to spend some time with Judge Fleischer finishing up that trial, let's go over to Judge Meineke.
This one, you'll get all the information, but as you can imagine, as Mr. Duncan is at a stage right now where things are coming quickly and there are important dates that are coming up, graduation, proms, things like that. I want to make sure that he is making the healthiest, most positive decisions possible, because it's hard to, really help a young person understand that, yes, the stuff you do when you're 18 could follow you around and impact you in a negative way for a long, long time. And there does seem to have a feeling of injustice in that, that you're just getting started with your life. And if you make a poor decision, that it could have that kind of impact, but it can. And I don't do you any favors by not telling you that. And I'm sure I'm not saying anything that Mr. Torres hasn't already said. But in the meantime, you need to stay locked in. Mr. Torres is going to be working hard to put you in the best possible position. The last thing you need is for me to find out that there's some other driving offense that's out there, or some other episode of poor decision-making that you engage in while Mr. Torres is trying to get this thing resolved. So all eyes on decisions that will keep you moving forward. Does that make sense?
Yes, Your Honor.
Are you looking at schools, trade school, work? What's next steps for you?
I was looking at Schoolcraft and possibly getting my associates just in possibly automotive somewhere.
Great. That's
So
great.
I'll tell you, he does have great family support. His father, you can kind of see his arm. He's there, and we're working through this, and I think everything will work out fine.
Great. Well, Mr. Duncan, I'll learn a lot about you in the next couple of weeks. So make sure you get things done the right way. Follow Mr. Torres's lead. He's been in this court many, many times with individuals in very similar situations and help them move forward. He'll do the same for you. Mr. Torres, I'll see you in 4 weeks. Good luck.
Thank you, Your Honor. Have a good day.
Everybody can log off.
All right, don't know the specifics there, but obviously a young man who had something going on, and hopefully since he's only like 18, he gets it together. Let's go over to Judge Simpson.
Prosecutor there had spoken with jail staff about possibly getting a petition if the CMH worker in the jail, that does not appear to be something that can be done. What we then tried to do, or are in the process of trying to do, is work out a plea with Mr. Jolly. Mr. Chabalowski, who's the 15th District Court prosecutor, and Mr. Gaddy Mr. Gaddy just kind of going as standby counsel, attempted to go to the jail and speak with Mr. Jolly, I believe last week or the week before, but there was an issue with actually getting him to come up and speak with them, so they weren't able to facilitate any conversation about any sort of resolution.
Actually, Your Honor, Mr. Chabalowski and I, Mike Gaddy from the Public Defender's Office, Judge Perry had, he has not asked for standby counsel, but just in case he changes his mind while he's talking to the prosecutor, she asked if I would go, and I agreed. And we tried to go down. It was not a good time for the jail, so we're planning on doing it later this week, and we haven't had a chance. We're hoping to go tomorrow. Okay. So we did attempt to see him, but he didn't refuse us. But I mean, to be candid, he's refused everything else.
What do you wish for me to do?
I'm merely a reporter in this.
Yeah, no, I got you. Well, until we can figure something out, I mean, this is sort of at a standstill. I mean,
I guess at this point, we'll give them a chance to see if we can have some sort of conversation.
that's fine. So what I will do, I think, haven't we sent him for comp already?
Found
Competent.
competent, although the thing that struck me about that is that CFP relied on the earlier finding of competency, having not seen him for all.
Correct. So, all right, I'll adjourn the probable cause conference in this case to May 22nd, 2025, 9 a.m.
Thank you.
Bond continued. All right, thank you. All right, we're all set. Thank you, Lee.
Thank you.
Court calls the case People versus Byron Blair.
National the people.
Honor Alexis Plume, appearing with and on behalf of Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron Blair. All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon a successful plea to that charge, count 1, retail fraud, and the first would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him as well as an advice of rights, which should be in the file as well.
Have it. All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Byron Blair. All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree. Yes. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Yes, sir. All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir? Okay. Okay.
Understanding all of that, do you still wish to plead guilty?
Yes.
Are you sure that's what you want to do?
Yeah. You scared me, like, who was Valvo? Like? I'm sorry. You like, are you sure?
Like, who is Valvo?
Talked about the.
Oh, she's the
judge
chief
in
judge of the 15th District Court.
In downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you. You're
Oh,
gonna be
I
sentenced
got you.
Okay, what do you got me for? What are you telling me?
No, I understand what you were saying. Like, the way you said it was like I was just imagining the executioner or something. Oh, like, I was scared for a minute. Like, who is Valvo?
Oh, so you
Like,
thought Judge Valvo was an executioner?
Yeah, like you know, it's not gonna be me.
No, I'll call her today and let her know.
No.
I mean, I just to share that information.
No, sir, I'm sorry. Okay, I'm sorry.
Wow, and of all the judges. All right. Okay, you're clear now. I'm just taking your plea. You would have a right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
you. You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you still wish to plead guilty to
Yes,
the
sir.
charge? You do?
Yes,
All
sir.
right,
Yes,
and
sir.
to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, yeah.
All right, you signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off. You're not under the jurisdiction of any court at this time.
I'm on probation. No,
He's on
no, I
probation
just
out of
took
Wayne
probation. I'm
County.
trying to get all of my stuff together. I've been on.
I don't know what that meant.
Counsel? He was not on probation or parole at the time of the
No.
offense. He has now recently been sentenced to
Thank you.
probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, I am.
Of your own free will? And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Tell this court what you did on that date involving the M-Den store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay, I got it. So you went into the store, you took property that the store had for sale.
Yes.
They were open to the public.
Yes, yes.
And you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
Sir.
All right. And you didn't have anybody's permission to do that?
No, I didn't have nobody.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo. Not execution.
All
right.
And Your Honor,
I'm gonna call her though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure. And that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there, as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th, he would get a.
Please go on.
I'm sorry. I do believe his other cases in 15th would revert to personal bond if he was given a personal bond on this case.
Any response?
Your Honor, this is one of 5 pending cases holding the defendant right now. They're all retail fraud. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case. So I'm gonna request that bond continue at least until the time of the TSIR.
I tried, but I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital. You were going back and forth between
I
Wayne County and here.
I called your office up here, and I was known that it was a mistake because Y'all had me down as being in custody doing
Y'all,
Zoom.
that's me.
Not y'all, okay.
Go ahead, no, I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah, the big
Okay,
y'all.
yeah, okay, go ahead.
Okay, it was a mix. Okay. One incident. I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
Acting really, why are you nodding like all this is? No, go ahead.
Like this is crazy. I just been ping ponging back and forth between Wayne County and Washington. So while I was in Wayne County, they never Zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washtenaw County. For what? For not going to court. I said, okay. I come out here to Washtenaw County. I ended up in custody trying to figure out how to turn myself in. I come back up in here, y'all set me another court date. Now guess what happened?
That's it, big y'all.
The Washtenaw County court system.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washtenaw County for missing court. I'm like, I'm ping ponging back and forth. When I just got my tether off on the 11th, they called y'all Washtenaw County.
Y'all, all of us?
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
because you gotta have a lien. You gotta have a lien when you get sentenced to probation time. So I went in prepared to come in, right? And this and that. They told me, advise or release, take care of it when you get up here. So I got up here. I got with my caseworker, this, that. I was supposed to be going to this transitional housing stuff set up, this and that. I made sure I had my housing stuff set up here first. And then now I'm trying to see what you.
If I give you a PR, will you stop?
If you don't send me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That to be your first time.
All right, sir.
Well, he's got other holds that are going to hold him in, but if you're asking me to reduce this bond, it right now it's at 1,000 cash or surety.
No, they said that the bonds that they gave me that it will convert into.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I got it. I was just ready to rule and he started talking again.
I think he did a great job.
He did. He did a fantastic
Better than
job
me.
for the last hour.
Yes, Your Honor.
That's what.
Yes, there were other holds. I said yes.
And
4 other cases that have.
4 other cases. That's what you were saying.
Yeah.
Before we.
And I'll just put the court's information to you. I see a 2019 case, a 2022 case, a 2023 case, and a 2024 case.
Grant the request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond.
Thank you.
You're welcome.
Thank you.
Take care. And I've already sent a message to Judge Valvo. She's waiting for you. All right, take care. Bye-bye.
All right,
Court calls.
Okay, so a few minutes ago we were kind of talking about some serious stuff and kind of what I have an expectation for this community and what I want the channel to be. That we're seeing law, we're learning, we're discussing, we're laughing, we're appropriate, we're having fun. That is what I want for this community. If you're ever questioning what it is that I'm hoping for all of us here in this space, refer back to that. That was enjoyable. It was fun. It was palate cleansing. I think we needed that. I hope you agree. All right, lecture over. It's time to get back into the Wayback Machine and go to tomorrow. We voted as a community, in case you weren't here yesterday, that after almost 5 hours of listening to a DWI trial, we did get through testimony. We agreed to come back today and do closing arguments and the verdict. So I have those in two separate parts. So let's go back to yesterday, Judge Fleischer's court, and we will listen to closing arguments from the DWI trial that he held.
Verdict sheet. Each side will get 20 minutes for closing. State.
The United States waives its opening and reserves its time for closing evidence.
Okay. Defense, you may start.
May I proceed, Your Honor?
Please.
I told you at the beginning of this case, in my opening, of the things you would not hear. I told you would not hear what his exact speed was. And I told you would not hear what his blood alcohol content was at the time he was driving. Out of all 4 witnesses that the state has put on, not a single one of them could say that with absolute certainty. Nobody can tell you either one of those facts. You heard from the analyst who said that he would need specific facts to determine what his alcohol level was at the time. He talked about absorption, how alcohol enters the body, how it takes some time for the alcohol to enter the body. And when asked, can you do that in this case? I believe the state asked him that. He couldn't. So we don't know what his blood alcohol content was at the time of driving. We know what they claim it was, or what the sheet shows it was at the time that he blew. That doesn't mean that's what it was when he was driving, right? Then he talked about the mental faculties and physical faculties. And the analyst told you that he believes somebody with a 0.08 loses all faculties, right? And I asked him, does that include driving? He said, yes, I believe it includes driving. I said, would you expect to see other driving patterns? Would you expect to see swerving? Yes. Would you expect to see an accident? Yes. None of that happened here. It was supposedly speeding was the only issue, right? And let's talk about the speeding. Officer Metter found northbound on South Chestnut. He says he knows that intersection well because the station is not far from there. And he knows how fast somebody's going because of the flow of traffic that goes from there. There was not a single car on that road, not one. He admitted it. My client had the green light. He didn't run a red light. In fact, we see him stop at the appropriate place at the next intersection. But doesn't run a red light. There's no traffic to compare his speed to. Metter waits 10 seconds before even pulling out, or 8 seconds before even pulling out and go after him. And then when he does go after him, he claims he hit 64. He says that you can see that on the video. We didn't see that on the video. There's nowhere on that video does it show what his speed was. Why? Because we don't know what his speed was. That's just what he said it was. Right? The evidence speaks for itself, ladies and gentlemen. Evidence speaks for itself. So then he says it's about a quarter mile to the next stop. So if he's doing 65, and my client's doing 65, he even admitted to you, Metter admitted to you, that my client would have been long through that next light before Officer Metter even hit it at a quarter mile. He was not doing 65, ladies and gentlemen. In fact, we don't know how fast he was going. Why don't we know how fast he was going? Because Metter didn't try to put a radar on him. Didn't try to do anything except pull out and say, I'm going to go stop this guy. And then when he gets up there, Here's where the state wants you to say, oh, this is a problem. This is a reasonable cause or a probable cause for the stop. He runs his plate and finds out the registration was expired. Okay, I asked Mayor specifically, is expired registration indicative of intoxicated driving? Of course not, right? It's a fix-it ticket. That's what you get. You gotta get registration, pay the ticket, case gets dismissed. So, and I asked him, but for the fact that you perceive my client to be speeding, would you ever run his plate? He said no. Why? Because he was going the opposite direction. He was going northbound, client was going eastbound. Westbound. Had to do the never eat soggy Wheaties. Yeah. So client was going westbound. Complete opposite direction. So, but for Metter thinking that he was speeding, he would never pull up behind him. He never pulled up behind him. He would never run his plates. He never run his plates. He would never have seen the registration was expired. And therefore, my client would never have been pulled over. Let's talk about the investigation itself. When he pulls into the gas station, Metter realizes Mr. Gomez doesn't speak English very well, so he calls for a Spanish-speaking officer. Ruiz shows up. Ruiz starts talking to him. And Ruiz told you that he didn't translate everything verbatim. He paraphrased it, is how he put it. Metter testified that there were inconsistencies in my client's statement, which led him to believe that he maybe didn't have the mental use of his faculties due to intoxication, right? But there were no inconsistencies. We heard Ruiz talk about coming out from Cleveland, helping the client move. Ruiz didn't translate that all. All he said was he came from Cleveland and he helped the friend, right? Then later on, he says again, he helped the friend move. And then Ruiz says that. And then Metter tells you, well, that's an inconsistent statement. He told you he came down to get gas. He was coming from his house to go get gas because gas is cheaper on the side of town, right? That's what that's what the client said, right? And Ruiz said that. Officer Metter says, oh no, that's an inconsistent statement. He never said anything about getting gas before. He said he had come down, helped the friend move. He said that the first time, and he said it the second time. And then they asked him, well, where is he going? He said, I'm coming down here to get gas because it's cheaper, right? So he came to get gas because it's cheaper in that thing. Then Metter goes on to talk about, oh, why'd you pass all these gas stations? Well, we all know there's gas stations everywhere. Every single gas station has a different price. I know I've got my favorite one I always go to, and I will pass a dozen other stations to get to that one to get the cheapest price on gas, especially nowadays, and especially coming into the summer months. We all know that. So everything that Metter told you or used in the totality of circumstances is perfectly reasonable. Now let's talk about the field sobriety tests. They want you to start right here, like this, right? I'm struggling to do that, and I have perfectly good balance. You start here, and then you've got to do heel to toe for 9 steps, and then a series of small turns. I know the SFSTs inside and out. I was a prosecutor, I was a police officer, a prosecutor, and now a defense attorney. I've done these thousands of times. I've seen them thousands of times. All right, so I can do them. My client got 1 time on the instructions. Metter claims he took 8 steps instead of 9. Okay, maybe he miscounted. All right, and then a series of small turns. They expect somebody to do this to turn around. Right? That's not a natural movement. Everybody, when you turn around, when you're just thinking, I got to turn around and go back, you get to the end, you turn around, and you go back. No falling over. no stumbling, nothing, just an unreasonable test that is perfectly unnatural for a human body to perform. And he claims that the National Highway Safety and Transportation Committee established these so that it would be difficult. Sure, maybe that's the case. But even a sober person, I believe he even said, somebody, what were his exact words? It was relatively easy for somebody who is not intoxicated. Not completely easy, not perfectly easy, not easy at all. Right? Relatively easy for somebody who's not intoxicated. So the field sobriety test, useless. Absolutely useless. And then he talked about, him and Ruiz both said, there's a strong odor of alcohol on his breath. Right? But then I asked, if you have one, maybe 2 beers and have a strong odor of alcohol on your breath. Yes. I asked later, if you have 2 beers, are you intoxicated? No. And then we get to Varner, and Varner says it was a moderate to mild odor of alcohol on his breath. Which one's the truth? We don't know. We weren't there. But that's completely unreliable as well, because there's inconsistent statements. If Vedder wants to use the inconsistent statements, that's an inconsistent statement amongst the state. These are the people that work for the prosecutors. This is their job. Their job is to find people guilty, for the state, not the prosecution. Their job is to look for things to find people guilty. Right? That's what they try to do. So they're going to say what they want to say to get to that point. Now, as far as the jury instruction, there's a section in the jury instructions that says you are to disregard evidence if unlawfully obtained. Page, I believe it's 5. 1, 2, 3, 4, 5. Page 5. The entire section talks about evidence unlawfully obtained. I've already explained this to you, but I'm going to go over it again. Matter says he knows that intersection. Based on the flow of traffic, he believed my client was speeding. There wasn't traffic. He couldn't go after him. He couldn't tell how fast he was going. Then he goes out after him. A quarter mile later, he catches up to him and runs his plate. That is, without him thinking that my client was speeding, he would never run that plate. That's unlawfully obtained evidence. He just looked for something to find.
Objection, Your Honor. May we approach?
Why just lose it? I said, but for him going after me. Or so. Okay, that's an end of it. Right, and so so you can as well. All right, come on. Okay, 3 minutes.
So, again, speeding goes in behind, runs plate. That tells you here down at the bottom, and or expired registration, right? What I'm asking you to think of is, why did he find out that registration is expired? What led him to that? But for him perceiving a speeding, he would have never run that plate. And if you find that probable cause did not exist, or as well as you don't believe that He lost his mental faculties. We didn't see him fumbling. We didn't see him walk, urinating himself. We didn't see him everything during jury selection. I think somebody said that. You know, they urinate themselves, right? They stumble, they act a fool, they're belligerent, things like that. We didn't see any of that. What we saw were those unnatural field sobriety tests that are designed for people to fail. That's what we saw. Nothing else. No other driving facts. So no loss of mental faculties, no loss of physical faculties. And then they say at the time that he flew, his alcohol was 0.153, but nobody can tell you what it was at the time he was driving. The law is driving while intoxicated, not intoxicated when you blow into the machine. Driving while intoxicated, which means they have to prove beyond a reasonable doubt that at the time he was driving, he either lost his mental faculties, lost his physical faculties, or was it 0.08 or higher. They have proven absolutely none of that. So ladies and gentlemen, the jury, you have one verdict and one verdict only. It's at the very top right there for you. We, the jury, find the defendant, Alberto Gámez Santa Maria, not guilty. Thank you very much for your time.
Okay, thank you. All right, state.
Thank you, Judge. Judge, may I publish a PowerPoint for the jury? May I publish a PowerPoint for the jury?
Sure.
All right. Defense said a lot of things. Some of it confusing. Some of it, right? Let's start with the jury questions. This piece he pointed out to you said disregard evidence if unlawfully obtained. There's a piece I want to circle here. It does not say if you must all agree the state has proven beyond a reasonable doubt that Officer Metter reasonably believed that the defendant was speeding. It says was speeding and or had expired registration. Ladies and gentlemen, it isn't hard. The officer thought he was speeding. He goes to the line, the officer sees him, he follows him, he tracks him, he pays him. Was it perfect? No. But he gets up to the light and he runs his registration. He finds that his registration is expired. That's all he needs. That's it, right there. That's what the jury instruction says. It says or. If you find that he had expired registration, it doesn't matter. Look at all the evidence. Now, let's go through this and let's make it easy. Like I told everybody. Every single person, except for the last witness, said that this occurred on October 6, 2024. That's an easy one. Let's cross that one off. The officers both said it was in Harris County, Texas, and in a public place. We know that it was this defendant. How do we know that? Because the officer said it was. Because the officer said, I was going down the road, I saw this car, I pulled him over, and he was the one behind the wheel, and you see him on the video. Let's cross off another one. Operated in a motor vehicle. How do we know that? You saw it on the video. The officer told you everything you need to know. It's not hard. In a public place. You see on the video, he's at a gas station. The officer tells you he's at a gas station. And he's operating the vehicle on a public roadway. Straight from the officer. It's not hard. None of those are hard and fairly easy. Then we get to while intoxicated. This is still easy. Why is it easy? How do we know he was intoxicated? Because I have this piece of paper that says subject name, that has the operator that you heard from, his signature on it. And it says what his DNC was when he blew. Now, this is important. What does it say? Let's use the low one, 0.153. This is a smaller detail that you may not have caught, but you have to use your memory. Think back. When the officer was telling you about the HGN, you remember there was a small part at the end of the HGN where he said onset, he was talking about the onset prior to 45. And it's what the officers used to calculate about where the defendant is on the scale. He told you what he thought the defendant was at that point in time was what? It was around 0.15. And then he went and got a breath test and he confirmed it. So it doesn't have to be hard evidence. Remember yesterday we were talking during jury selection and I brought up Stonehenge, and I said, and I told you, you might not have the full picture, but you don't need the full picture. When you get enough pieces together in a puzzle, you know what the picture is. And that's all this is here. We have all the pieces we need. Only thing left for you to do. So go back in the jury room, pick a form, and return a guilty verdict. That's what I'm asking you to do right now.
All right, thank you. All right, ladies and gentlemen of the jury, it's now time for you to deliberate. Get you going. Do you mind escorting them to the jury room?
Okie dokie, everybody. That was closing arguments. A couple of things that I didn't mention ahead of time. First off, they had some hearings that I didn't cover because it was fairly routine, but it was involving wording in the jury instructions. There was some problems with that they cleaned up. I also skipped over his reading of the jury instructions because, frankly, there wasn't anything there that, if you've watched any level of Courtroom, that you haven't seen 1,000 times before. There was nothing special about it. Also, they stipulated the defense and the prosecution to what the sentence would be if he's found guilty. So that's already been sorted out as well. So give me just a second while I switch this over to the video for the sentencing. I will say this. They returned a verdict very quickly. Judge got notification that they had reached a verdict about 10 minutes after they were sent to the jury room. Before I switch, though, give me your predictions in the comments, or in the chat, rather. Guilty, not guilty? Put it in there now. We'll take a minute and wait for your thoughts, and then we'll pull it up and see what happens. Yeah, Kazman, it was very quick. Bailey thinks guilty. Anybody else got thoughts? Ashley, guilty. Kaz thinks not guilty. Yeah, sometimes a quick verdict can also be not guilty. It's not necessarily an indicator. Brandon says guilty. Even more certainly came back guilty. Yeah, okay. Swamp Fox, guilty. All right. RJ, guilty. Well, if you guys are the jury, it's not looking good for this guy. All right, let's go ahead and get over to that and see what happens.
Okay.
Again, if
Ladies
there's any,
and gentlemen of the jury,
if there's
have
any
you reached
audio
a
issue, let
verdict?
me know.
Is it unanimous? Okay. I'm now going to read to you in the state of Texas, cause number 2532700, the state of Texas versus Odir Alberto Gomez Santa Maria. We, the jury, find the defendant guilty of Class A driving while intoxicated as charged in the information. Okay, you've been found guilty. You may take a seat for a moment. Does anybody who would like the jury polled?
Yes, Your Honor.
Okay. Ladies and gentlemen of the jury, is this your verdict, man? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Your verdict?
Yes.
Your verdict. Okay.
Thank you.
All right, sir. Just give me a second. Ladies and gentlemen of the jury, you have concluded your service. I thank you for everything that you've done. It's really an invaluable service. You may now retire to the jury room. If you give me a couple minutes, I'll come back there and talk to you, and then we'll try to get you all the things that you may need to get you out of here quick. Yeah. Thank you.
All right, for the jury.
Please be seated. Mr. Gomez, I want you to understand that you do have the right to appeal this verdict. If you decide to do that, there are certain timing requirements that must be fulfilled and documents filed. I can let your attorney explain as much as he knows, if that's something that you want to do, but timing is of the essence if you want to appeal this, but you do have that right. We do have to sentence, and if I'm correct, parties, you have agreed to a sentence.
Yes, Your Honor.
Okay, and the agreement is
210 days.
with credit for the 73 days. Okay. I'm now going to sentence you to 200 days in jail. I will give you credit for 73 days that you have done. Mr. Gomez, you need to understand that this will now reflect as a conviction on your record. This now makes 2. If you ever pick up another DWI, you will be charged with a felony offense, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip of alcohol, get into a car and drive because you are taking a huge risk. Do you understand? Okay, so you may be seated, and I think that.
Are we gonna keep it as a second with the Class A?
Yeah.
1.5?
Yeah.
So it's making sure, okay.
Yes. Well, they found it.
No, they found the .15 true. The second is an punishment enhancement, which would need to be found true as well.
Yeah, but we were stipulating.
We.
Guilty.
Yes, we'll stipulate to the first.
Okay.
Doesn't really change anything.
Right, okay, so we need him to sign documents, so just don't send him down until the documents are ready to be signed. I'm gonna suspend the license for a year, okay? Do not drive until you get a license. Otherwise, you'll be right back in custody.
Just for the record, Judge, although I've admonished him, the court admonished him that this could have negative effects on his immigration status.
Right, okay, yes, that's in fact true, right. You being found guilty of this DWI offense, this can and probably will impact any kind of immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You have an ICE hold now, so you know now that there are immigration consequences for future purposes. When you're on bond, don't violate, there are severe consequences, as you now know. Anything else you'd like?
No, Your Honor.
State?
Doesn't really say how.
No fines.
Okay.
Yeah, I'm not, no fines, nothing else, just, I'll waive any kind of surcharges that will be imposed by the Department of Public Safety. Right, so if you don't mind giving me the motion, and then I'll sign it for you.
Thank you, Your Honor.
Okay, all right, so just hang tight, but don't send them down just yet. Okay. All right. Let me go talk to them real quick and then I'll let you guys go talk.
Okie dokie. So guilty. And the thing that caught me at the end personally that kind of clears up why this defense attorney was perhaps throwing so much ridiculousness against the wall, hoping that something would stick, is he's got an ice hold. And this is gonna, quite honestly, potentially seal his fate there. So that kind of cleared that up for me. Let me know your thoughts in the comments about how that turned out. Real curious. I'm not surprised by the verdict, though I thought that there was a hole there for a not guilty verdict just because of how long the prosecution dragged things out. I really felt that there might have been a problem with information overload on that one personally. It went on way too long, in my opinion. But, that's just my thought. Real quick while I queue up the next thing, apparently in Judge Shackelford's court, if you'll notice, she's engaging in the Young Judges program. I'm assuming that's maybe her son or something. I'm not sure. I believe she has a couple of kids, but I just thought it was kind of cute and kind of funny. Let's go over to Judge Simpson again.
Yes, Your Honor. Were you on probation or parole at this time of these offenses?
Yes, Your Honor.
All right. Then I need you to understand your plea in this case could be a violation of that probation. And you need to understand that as such, that other court could sentence you to the maximum allowable under those other charges. You understand that?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty to these charges?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
And of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
All right. March 17, 2024, at the location of M52 near Newkirk Road, Manchester Township, Western County, State of Michigan. Were you operating a motor vehicle?
Yes, Your Honor.
At the time, was your driver's license suspended, denied, and or revoked?
Yes, Your Honor.
And did you know that it was?
Yes, Your Honor.
All right. And while you were operating that motor vehicle, did you have open intoxicants in the motor vehicle?
Yes, Your Honor.
What'd you have?
I had an open tall boy, which is open beer.
Really? Like I didn't know, because I just crawled from under a rock. I get you. You had an open beer in the vehicle, right?
Yes, Your Honor.
Okay. And you knew it was there?
Yes, Your Honor.
All right, and it was yours?
Yes, Your Honor.
All right. And had you used a controlled substance on that day?
Yes, Your Honor.
What?
Adderall.
All right. Did you have a prescription for it?
No, Your Honor.
All right. And you knew what you were using was Adderall?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 and 4 probation. Sentencing will be June 10th, 2025, 9 a.m. before Judge Fresh Hour. And on this will continue. Mr. Howell, good luck to you, sir.
Thank you, Your Honor. It's been a pleasure.
Thank you. Court does call the case of People versus Michael McLean.
And on behalf of the people, Your Honor.
Basically, on behalf of Mr. Michael McLean, who was present to my right. You state your full name for the record, Michael?
Michael James McClain.
Thank you.
Today is the date and time set for a probable cause conference. At this time, we'd be respectfully requesting to set this for a final settlement. I'm sorry, not final settlement, preliminary exam.
And your people can just bond.
Yeah, of course. Hang on. Would people have their witnesses available on the 6th? Preliminary examination in person, May 6th, 2025. 9 a.m. Is it 12? 12 noon. That's before me. Yes, I should bond.
When it's come to my attention, he has made 127 attempted calls to the victim since arraignment was 2 completed on 4/16 and 4/8.
How many?
127 attempted calls, 2 were completed. So I'd be asking that his phone privilege be revoked.
Oh. Response?
No comment at this time, Your Honor.
His bond will continue. His phone privileges are hereby ordered revoked.
Thank you, Your Honor.
He should maybe talk to Mr. Wiggins from Judge Fleischer's court if you didn't follow the the phone saga there. That thing went on since October. By the way, speaking of the phone saga, if you did follow that, there was a conclusion to it, but it wasn't video worthy because it lasted about 5 seconds. The long and the short of it was the jail finally agreed to just block the complainant's phone number for everybody. So that's how that got solved. Why that couldn't have happened in October got me. Couple things real quick for channel members. First off, go to your channel member page, and I just made a post there where you now have a dedicated email address to reach out to me. It is for channel members only. Feel free to reach out if you have questions, comments, ideas about the channel, just want to chat, whatever the case may be. That's a way for you to get a hold of me directly outside of the live show chat or comments on a video. You know, a little more personal. We can talk about things outside of the channel if you want, whatever it takes, whatever you want to do. Also, channel members, very soon you're going to be involved in helping us shape the direction of a couple of projects that we're going to do. Mrs. The Courtroom Files and I spent some time yesterday covering some ideas. We're going to flesh those out, and you will be the first ones to have access to them and judge them and help us shape them. So if you are not a member and you want to be a part of those things, it is $2.99 a month. It is super inexpensive. It's a great way to support the channel and join the more inner community here at the Courtroom Files. You can go to the pinned comment in the chat and use that link to get there. Let's go to Judge Fleischer live this time instead of the Wayback Machine.
Okay, so that's, I just took out the, if you want to take a look. So my only concern is just no contact with the complaining witness. That's all I'm concerned about. Yeah.
Special work, Judge.
Great. No, I didn't do anything. The only thing I took off is where it says other persons, you know? Yeah, thanks.
I guess he doesn't have a lot going on. Let's go to Judge Meineke.
Like to say before the court sets the fine?
Just that, Mr. Wise was just in some unfortunate circumstances that day, didn't have his license, but does have a license, which I know this court takes very seriously, and he got his business done last year. Just ask the court to consider minimal costs and fines, considering the circumstances.
I agree. Mr. Wise otherwise had his house in order, so I'm not going to. And the tint was taken care of?
Yeah.
That's all set now?
Yeah.
Okay. So to the charge of public nuisance, and just make sure going forward, if you ever do have a vehicle with a tint in it, just make sure you have all the documentation for it, all right?
Yeah.
But on the charge of public nuisance, the maximum fine is $500, but because he took care of everything, I'm going to reduce it down to $100.
Thank
So
you.
if I give you a month to pay it, is that enough time?
Plenty of time.
Okay. Who's with you, by the way, today, Mr. Wise?
That's my mom.
Okay. So I always think it's a good thing to have a mom looking over your shoulder. Doesn't matter what age it is. All right.
Right.
My mom lives a mile from me, and she's always looking over my shoulder, and I'm a judge, and I'm almost 50. So it's never a bad thing to have moms around. Right, Mom?
Right. I agree.
So see, when he says So when he says like, you know, get off my back or anything like that, just say, wait, a judge said that I'm supposed to stick around and stay involved. Okay.
Correct. Thank you. You hear that?
All right. So you're all set, Mr. Wise. Just take care of that $100 in the next 30 days. Good luck.
All right. Thank you.
Thank you, Your Honor. Have a good day.
We're back up. Okay. Let's see. Okay, Mr. Dubin, can you hear me okay?
I can, Your Honor. It sounds a little far away, but we can still hear you loud and clear. Good morning.
Good morning. I can always project my voice, so I'll take care of that. Are you ready on Porter?
We are ready on Porter, Your Honor.
Okay. $25,00530 people versus Robert Porter.
Let's actually move on from that. When he moves out to his courtroom, the audio gets a little rough. Let's go back to Judge Simpson.
Honor, he is just providing an explanation as to why he wanted to eliminate the possibility of contact. It did pop up. He did remove it. He's asking that the court, he blocked her. He is asking that the court take that into consideration. He's asking, we are pleading with the court to allow him to remain out on bond at this time. And he was, for what it's worth, honest with the court about that. He is taking accountability for it.
Anything else? Tell you not to have contact. He sees her face. He attempts to make contact with her. He can't violate the bond that way. Just plain and simple. Defendant's bonds revoked. Defendant's remaining. Court case, People versus Bruce Pickkins.
Stephanie Can on behalf of Mr. Pickkins, who is appearing to my right. Mr. Pickkins, could you please state your name for the record?
Bruce Pickkins.
Your Honor, you should have a green sheet in your possession. I'm simply asking for a 2-week adjournment. An AIM request has been done for my client to see if we can get some mitigation.
Said 2 weeks?
Yes, sir.
Thank you. 12 days. So I'll set probable cause conference in these matters will be May 6, 2025, 9 a.m.
Also see you before then, and you'll hear from our staff to try and get you some mental health and also start working on the home.
Bond will continue. Thank you.
Thank you.
Case, People versus Marcus Jones.
Judge.
Hey, how you doing? I'm doing.
Marshall Fleischer, First Assistant Public Defender on behalf of Mr. Marcus Jones. Mr. Jones, please state your name for the record.
Marcus Jones. Thank you, sir.
Thank you, Judge. I think we were here a couple weeks ago, which time Mr. Jones was in treatment. He is now out of inpatient treatment, out of the hospital, but he's going to be going back into a outpatient
program.
Right. So my understanding is once he completes that, that might have an impact on the resolution in this case. So I'd ask for 3 or 4 weeks or more adjournment so we can get him going.
If I may, Your Honor, I did attempt to do I'm sorry.
Okay.
I did set an appointment for myself, but I missed it, so I had to reschedule another appointment. So I was planning on scheduling another appointment after court today.
Today. Okay. All right, real good. Let's do this then. Let's see how you're doing through the program and everything. I'll adjourn it out to May 29th.
Okay.
Okay. Thank you.
Okay, you're welcome. 2025, 9 a.m. Okay, you take care of yourself, young man.
We're
Got
not-
something ready.
Yeah, I'm making a hallway out. Okay.
Okay.
Thank you, Judge.
Court calls case, people versus Scott Reese.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Reese. Please state your name for the record.
Scott Reese.
People are going to be filing a no leave cross in this case.
Objection.
No objection.
Case is dismissed.
Missed all 3 counts.
Okay, thank you.
You're welcome.
Thank you, sir. And then why were you like giving him the fist like you did something? You didn't do, you didn't know, you did nothing. You did nothing. You did nothing. That was Miss Apple's victory. You just, you know what? Just don't even try it.
That's all for one, Your Honor.
Court calls case, people versus Maurice Kihei. Or Kihei.
And Lieutenant, on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Kihei. Mr. Kihei, you can please state your name for the record. That's how you pronounce it, right?
Yeah.
Okay.
Maurice Kihei.
Kihei.
Your Honor, can you briefly approach?
Oh, boy. Bellinger, really? It's like every week. This is a problem.
Every week?
Yeah.
When's the last time I was at this bench?
Last week. Yeah. It was.
All right, he's going to mute, so let's go back to Judge Fleischer.
No, if they gave her a PR phone?
I don't, but also, yes.
You know what?
And
it's just the one.
Yes.
Corinth, did they give her a PR phone? I guess, Anna, you wanna roll it?
That's fine with me. I know you guys don't like to do too much on, or put too many cases on the docket for Friday.
No, I don't, for this,
Yes.
they gave her a PR bond. Hey, they gave her a PR bond.
Okay.
Serenity.
Is there any way I can ask you to set her a cash bond if she's in processing? So hopefully.
She's being released as we speak.
Okay.
So she'll get a 7-day setting on the field. No, I'm not gonna override the match. I'm gonna let them do what they do and then I'll deal with it.
I will try and get her here tomorrow.
Roll it to tomorrow. I said.
Okay.
Question though, so we have this guy on standby for that.
Don't worry about it.
That's what it's on.
Okay.
I'm not even concerned about that anymore.
Okay. Okay, thank you, Judge. Maybe excused. Thank you.
Hi, Judge Members. Morning, Judge. I got Mr. H.E. on your document today.
Okay.
Judge, so here's kind of where we are on this. We received the DDR PTI contract yesterday from the state. He's getting together everything through whatever scheduling error that we
We
had.
got the contract back,
Got the contract.
so we'll just give you time.
Okay.
I don't
Only
need all
reason I
those.
say that, Judge, his appearance was required today for.
Don't worry about it.
Okay, so.
You're okay. Yes. Oh, no, you're 164. I'll give you 30 days.
Okay,
You want
that
it.
works.
Okay.
Appreciate it, Judge. Thank you.
Have fun. Wait, has he done, you got the contract, so he's done the T-RAS. So, I mean, I trust you. Josh. Is she here?
He's here, Judge.
Great. Shall we get it done?
She's not accepting any offer, and I think they're gonna be refiling as a felon in possession case, essentially. The state's gonna be dismissing this case, so this is my understanding.
Christian?
I'm.
So
Can you bring her up? Can you bring her up? I'm so sick of playing this. This is just.
This part.
I'm sending this for trial right now. I'm not taking anything. I'm tired of this game. If she ever shows up at 1 PM, I'm gonna hold her in contempt. How long when can we get this trial?
So Judge, I know we were going back and forth with this too. Sorry.
I looked at this, you can look at it every day. I think it's clear, I think it's strong, even more so strong.
Are you gonna, what are you gonna do?
I'm feeling grand jury today, I'm gonna try to get the grand jury to call in.
They have given you an offer in this case. By you rejecting it, he's telling you now he's gonna go to grand jury to have it indicted as a felony. And you're gonna be looking at a 3rd-degree felony. You realize this? You want to set this thing for trial? Or what do you want to do?
I'm fine. That's fine.
Okay.
I'm gonna get email grand jury today.
You were set for trial this Tuesday and you showed up at 1 p.m. If you do that again, I'm going to have a contempt hearing and you'll be facing an additional 6 months in jail and a $500 fine. Do you understand me? When you were set for trial, you were to appear here at 8:30 in the morning, not 10:02, not 11:51, not 2, 8:30 in your seat. Do you understand? So how long, what's the soonest trial setting we can do? In the event that you don't get it indicted, because
I just asked for 30 days, just so we can get all this things out. There's all that. I mean, actually, they should have been done already, but we love it, just, I don't want to put either Cole or John in the spot.
okay, so this will be set for trial May 20th. I'm sending you now for a drug. Did we send it for a drug test yet?
I believe you did on Tuesday, Judge.
Sent her on Monday, I believe, and she was for something positive for THC and coke.
Okay, I'm revoking your bond. You're going to custody right now. She goes with you. Unacceptable. And now we set it for trial May 20th.
Give everybody a call.
5,001. Yeah. Hi.
Good morning, Judge. We're approaching on Christopher Smith.
Okay.
He's on, it looks like the 14 days are up. The state is asking for one more day.
Yeah, we're just asking for an extension so that we can pick up tomorrow.
And Mr. Smith would not agree to that.
I get it. I give one extension if for 1 day it's okay. Okay. All right.
All right, thank you, Judge.
Yes.
Okay, Brandon, to address your question that you just put in, when he says 5,001, is that the full cost of the bond? If not, why not just say 5,000? He uses that to code. As I understand it, it has to do with like the number of cases that he has. So there's one case, so it's like 5,001. If there's like two, it'd be like 5,002. That's my understanding of the coding. But that seems to be what he does there. So I'm going to go ahead and call it a day. We've had a pretty good day. Some definitely spirited discussion, some good court. We got to see the end of the trial from yesterday. Again, wasn't overly surprised by the verdict, though I did think there was a path to a not guilty, because I do maintain that the prosecution overdid it. You know, for if there had been some kind of property damage or injury or something like that, I could see going into all of this unending detail. But it seemed like too much. But they pulled it off, so what do I know, I guess. Thanks so much for joining us today. Appreciate all of you as always. I like doing this. I really do. I mean, and I hope you guys enjoy joining me every day. This is one one of the most fun things that I've done in my life. And the funny thing is 7 months ago, I had no idea that this would be something I would do because it wasn't on my radar. But one day YouTube started pushing me LawTube courtroom kind of videos. And I was like, I do YouTube. I could do it different. So here we are. But yeah, we'll see y'all tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Hope y'all have a good day. Tomorrow will be Arraignment Friday. Should be